Hello, you're watching Addleshaw Goddard's Employment Channel on the 12th of December. In today's news programme, we look at an important Court of Appeal decision recently hitting the headlines in the field of equal pay claims. We'll also look at an interesting case reminding employers of the principles of mitigation and how to reduce compensation payments. And finally, an update on the pensions auto-enrolment provisions. The Court of Appeal in Birmingham City Council and Abdullah has recently confirmed that employees are entitled to bring equal pay claims in the High Court, where the 6-month Employment Tribunal equal pay time limit has expired. This means that equal pay claims can be brought as breach of contract claims in the High Court up to 6 years after the breach has occurred. In this case, 174 employees brought equal pay claims against Birmingham City Council in the High Court more than 6 months after their employment ended, after discovering that colleagues had received equal pay compensation in the past. The Council applied to the High Court to have all claims struck out on the basis that they could be more conveniently disposed of by an employment tribunal, despite the fact that the 6-month time limit for bringing claims had already expired. They said that, given the nature of the claim and the specialist expertise of the tribunal compared to the High Court, it was more appropriate for the claims to be brought in the tribunal, and the reasons why the employees didn't bring their claims in the tribunal in time should also be taken into account. The High Court rejected the Council's application, and the Court of Appeal has recently upheld that decision. Laura Darnley, a managing associate in our employment group, comments on what this case means for employers.
The Court of Appeal's decision in this case is certainly interesting, as it confirms that employees can bring equal pay claims in the High Court up to 6 years after the date that the breach has occurred. This gives employees significantly greater scope to bring equal pay claims than under the 6-month Employment Tribunal time limit. And so it's clearly going to be a concern for employers, as it could lead to a large number of claims from individuals who found out well after the event, for example, that former colleagues have received equal pay settlements. So this decision is certainly one for employers to bear in mind, particularly if they have had or continue to have ongoing disputes on equal pay, as it potentially means that there are huge hidden liabilities to consider. But it's not all bad news. Given the significant cost risks in bringing a High Court claim, it's likely that only the strongest of equal pay claims will be litigated in the High Court. And for that reason, most claimants given the choice will still opt to bring a claim in the Employment Tribunal, where each party bears their own costs, and cost awards are still rare. Another key learning point for employers to take away is that on any sale or transfer of a business or services, employers should ensure that any equal pay indemnity protection is in place for at least 6 years to cover the risk of claims being brought in the High Court.
Thanks, Laura. We understand that Birmingham City Council is considering whether to apply for permission to appeal to the Supreme Court, and so if there are any developments, we'll be sure to keep you posted. Moving on now, in Dabiq and the Ministry of Defence, the Employment Appeal Tribunal has recently decided that a claimant who won her discrimination claim was not entitled to any compensation for loss of earnings, as she had unreasonably refused to accept a different job with the same employer. It's an interesting case, as it's a reminder for employers to consider offering alternative work as a means of resolving a dispute, even a discrimination dispute. In this case, the claimant was a single mother and she was a soldier at the British Army. Following her return from maternity leave, she found it difficult to combine her childcare and work responsibilities, and following an unsympathetic response from the Army, she resigned and brought race and sex discrimination claims against the Ministry of Defence. The Army was keen to explore the possibility of retaining her as a serving soldier and offered her a 5-year posting to a single location where she could combine her military and childcare duties. She refused the offer on the basis that it was only a temporary solution and she'd be faced with similar childcare issues at the end of the posting. Here the claimant proceeded with her discrimination claims, which were upheld by a tribunal, but she was only awarded £15,000 for injury to feelings and nothing for loss of earnings, on the basis that she had unreasonably refused the alternative job offer. The tribunal found that the new role offered a solid assurance of stable employment for 5 years, and whilst the future position was uncertain, it was unreasonable for her to refuse an offer that provided her with security for such a substantial period. She appealed to the Employment Appeal Tribunal, but her appeal was unsuccessful. The EAT agreed with the tribunal's award of compensation and held that it was unreasonable for her to refuse the job offer. Again, Laura comments on what this case means for employers.
As discrimination compensation is uncapped, and can therefore be substantial, mitigation findings can make a huge difference to the value and outcome of a claim. And so this case is an important reminder about the principles of mitigation and the potential value for employers in planning ahead to provide persuasive mitigation arguments. Here, the claimant requested 15 years loss of earnings, but she received nothing because of her failure to mitigate. And so although the employer lost the discrimination claim, its liabilities remained very low. Whilst in some discrimination cases, relationships will have broken down to such a degree that it would be reasonable for a claimant to refuse an alternative offer of employment. In appropriate cases, an employer should consider whether alternative work is a possibility. Even where alternative work within the employer isn't possible, the employer should consider whether there are other mitigation arguments available. The employer must be able to demonstrate that the claimant acted unreasonably in failing to take such steps. For example, by not applying for a position or not attending an interview. The employer will need evidence to support such arguments. This may come from recruitment or other relevant experts and should be compiled at an early stage in the proceedings.
Thanks, Laura. And finally, in our news programme at the end of October, one of our pensions managing associates, Rachel Utley, reported on new rules under which all employers will have to automatically enrol their workers into a pension scheme and pay contributions. The government has since announced some changes to the auto-enrolment timetable and has confirmed that the earliest date by which any employer with fewer than 50 employees on their PAYE scheme will have to implement the automatic enrolment pension provisions has been postponed by over a year to May 2015. The specific dates have not yet been announced. Employers with 50 to 2,999 people in their PAYE scheme will also have their start dates for auto-enrolment changed, but the new dates haven't been announced yet. We'll be sure to report back again if there are any further developments on this. And if you have any queries at all on this, please feel free to contact your usual Addleshaw Goddard contact or by clicking on the Contact Us box to the right of the screen. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.